how the law takes technology and how the law allows the government to use certain technological resources to solve crime, whatever that crime may be, and how the law has failed to keep up. So the only way to kind of understand this is I'm going to have to teach you guys the law. I'm going to give you now a crash course on constitutional law. You just saved yourself 3 years of law school because I'm going to explain to you guys in 5 minutes. All right. I said that the constitutional principle I'm really going to talk about is the Fourth Amendment. Fourth Amendment, here it is, the text. Here's the important thing that the Fourth Amendment says. It basically says that the government cannot engage in unreasonable searches and seizures. What that has traditionally meant is that the police have to get a search warrant in order to engage in a search or a seizure. And those are two very specific legal concepts, search and seizure. And we're going to talk about search specifically because it's a trickier issue, and we'll casually talk about seizure. Now, when I mentioned the disconnect, you can see it right here in the very text of this amendment, because it says the right of the people to be secure in their persons, houses, papers, and effects. That's what the founding fathers were talking about. House, okay, house makes sense. Their papers, meaning their diaries where they keep their thoughts. Their person is their physical person, and their effects, kind of all the stuff that's affiliated with a person. Well, what does that mean in the digital age? What is it? Does it cover this computer? Does it cover information I put on the internet? Does it cover my Twitter profile, my Facebook page? How about my cell phone? How about when I communicate with my cell phone and I send a text message to my wife or to my friend or whoever it may be? Okay? Courts are slowly dealing with these issues and they're struggling to deal with it. Why are they struggling to deal with it? Well, you have to go to what does it mean to search under the law. Now, when I say search, you probably are thinking about it in the colloquial sense, right? If you lose something, you're going to go searching for it. You're going to look under the desk, under your bed, okay? If you want to, when you go to the airport, your luggage gets searched. If you get randomly selected, they open your luggage and they go through your materials. So that's what we think of as a common sense term of what the term search means. Unfortunately, the law, and here's another thing you don't have to go to law school to understand, the law doesn't make common sense. It doesn't rely on common sense distinctions all the time. So instead of defining search by the thought or the concept of looking through a physical item, the courts have defined search, and the Supreme Court has defined search as really meaning two things. Okay? First, it means that the government intrudes on a subjective expectation of privacy that society treats as reasonable. Okay? This is kind of shorthanded. We call it the reasonable expectation of privacy test. If the government intrudes on a reasonable expectation of privacy, they've conducted a search under the Fourth Amendment. The second way the government can conduct a search is kind of going back to that more physical thought of it, and that is the physical occupation of private property for the purpose of obtaining information. Okay? This is the idea that if the government steps on your front yard to use some sort of high-powered surveillance equipment, or the Supreme Court had a case where the cops went inside someone's front yard and had a drug-sniffing dog, okay? That was a search. The act of stepping onto the homeowner's property with the dog to sniff the house was a search because it was the physical occupation of private property for the purpose of obtaining information. Now look, it's important to keep this one thing in mind. The Fourth Amendment applies to the government. It does not apply to private parties. Meaning private parties can do this, no problem, okay? They can intrude on, they can physically occupy private property, they can violate expectations of privacy. Maybe you'll get sued, maybe you'll get charged with a crime, but you're not violating the Fourth Amendment, okay? Now, the Fourth Amendment, what it really comes down to, and what is important for us to talk about, and how this interacts with cyber, and I promise we're going to get to cyber in a second, but what the Fourth Amendment really does is it imposes a couple requirements. And I mentioned there are really 4 important requirements, but there are 2 that aren't that important, which I'm not going to talk about, which are that a neutral and detached magistrate has to be the one that issues a search warrant, and it has to be sworn under oath. Not interested in that. That stuff's pretty boring. What the Fourth Amendment, the part I'm interested in, and the part that really applies in the world of cyber is, what the Fourth Amendment says, the police have to get a search warrant in most instances, but not always. And that search warrant has to have 2 very important defining characteristics. First, it has to be supported by probable cause. Probable cause is a legal concept that basically says the police have a really, really good belief or good suspicion or good idea that they're going to find evidence of a crime or contraband in the place that they want to search. Okay? Now, much of the litigation and much of the debate on applying the Fourth Amendment to new technologies and in the world of cyber is, are we going to require law enforcement, federal, state, whoever, are we going to require them to get a probable cause-based search warrant to do a search, or are we not going to have them get a probable cause search warrant? And believe it or not, in this country, there are a lot of areas where the law is in flux on this, okay? It was only in 2010, for example, that courts started to say, you know what, you have a reasonable expectation of privacy in your email, okay? Even though the US Supreme Court all the way back in 1896 said you have an expectation of privacy in a physical letter that you mail. So when you go to the post office with your taxes, okay, if you're getting ready to file your taxes, you expect that the post office is going to handle your envelope and they're going to see where you're mailing your taxes to, but you don't expect them to rip open that envelope and look through your mail, right? Only in 2010 did we first get a court opinion that said that same principle applies to email, okay? If you think about email, by 2010, email's probably on its way out, if you think about it. It's not the exclusive means of communication anymore. Now people are sending Snapchats and there's Twitter, there's Facebook, there's all sorts of things. But it took us so long to get to that principle because the law moves slowly. Even more interesting, and I think more challenging, is the Fourth Amendment requires what's called particularity. Basically the idea is that police have to have a specific place that they want to search, okay? And if you think back to the 1780s and what the whole purpose of the Fourth Amendment was, it was intended to eliminate the general warrant, which the colonists hated. What the general warrant was basically the British would go into someone's house and say, we're going to look around a little bit to see if there's anything here you're not supposed to have, and they would flip through all their stuff, and the colonialists hated this, and so they said, we're going to make sure our law does not allow the government the ability to just kind of rummage through your stuff. They got to have a good reason to rummage through it, which is the probable cause standard, and they have to be narrowly looking in specific places. So in the physical world, what that means is if, let's say for example, the police want to execute a search warrant on someone who lives in an apartment. They have to, when they go to the judge, they have to say, we want to search apartment number 2B. They can't say, we're going to search the entire apartment complex and see what we can find. They can't do that. And even with respect to apartment 2B that they want to search, if they're looking for, let's say, a gun, they're looking for a shotgun, their search has to be particularized to places where that shotgun could be. So it would not be reasonable for them to look through the mail on your table because you can't hide a shotgun in an envelope, a little 8.5 by 11 letter-sized envelope, right? So it has to be narrowed and particular. Okay? And now you're going to talk the Fourth Amendment in 5 minutes. So what's important about this is to keep all of these concepts in mind, because as we start to go through the kind of the cyber issues, you start to see there's some real difficulty in applying these traditional standards that are designed to safeguard our privacy interests from government intrusion in all sorts of new technologies. So here's an example. Anyone ever heard of a CPAP? Okay. In 2007, Wired, that tech geek magazine, reported about that the FBI had developed some malware. It's called a CPAP. What this malware did was it allowed the FBI to collect IP and MAC address information, URLs of the computer previously connected to, and a list of programs running, as well as a bunch of other stuff. And let me explain how the CPAP worked. They would basically send this malware to the computer of the suspect they were investigating. This malware would secretly install itself on the computer. It would then access all of this information, like IP and MAC addresses and URLs and a whole bunch of other stuff. And then what it would do is it would basically send the results automatically to the FBI headquarters in Quantico, Virginia. And it did this surreptitiously in the background. In 2007, what the FBI was using this for, they did it in a specific case where there was a guy in Washington State who was emailing bomb threats to some schools. They wanted to investigate him. They wanted to find him. They were having trouble finding him. They had only limited, information about how he was communicating online and electronically. So they deployed the CPAP. Now, the issue was they are very, very secretive about the use of the CPAP. And there's been, Freedom of Information Act request litigation that EFF has done, which is basically the legal framework by which you can request the government to turn over certain public records that they're obligated to turn over. There's been FOIA litigation on this, there's been reporting on this, about how the government has basically used and deployed these devices in cases and how they're doing so. So the issue in these cases is, well, do the police need a search warrant to do this, right? You would think that if they're trespassing into the computer, they're physically installing malware on the computer, you'd think, well, that's a physical occupation or private property for the purpose of obtaining information. They better get a search warrant to do it. And in this specific case, they did. But as you'll see, in 2013, the malware is developing and advancing in new ways. So I want to talk about freedom hosting. Has anybody ever heard of freedom hosting? Okay. So one person. Freedom hosting. Well, what is freedom hosting? Freedom hosting was basically a web hosting service. It was located in, the guy who ran it was in Ireland, but the servers were in France. And basically it was designed as a web portal to the dark web, the dark net. This is this like secret internet with all the bad stuff is on it, right? So you can buy your drugs and get your kiddie porn on it, and whatever it may be. And really, if you want to get into the technical of it, it was basically a website and a web serving platform for hidden services, Tor hidden services. Are people familiar with Tor? Okay, so I figured Tor is probably familiar. So let me explain what hidden services do. They're basically special websites that end in .onions that they basically are intended to hide the geographical location of where that website is hosted. You can only get to that website through Tor. And the idea is if you have a very sensitive set of information or documents or websites that you don't really want anybody to get access to but certain select few people, and you want to hide where you are hosting your stuff, you're going to use a hidden service. Like I said, there's lots of bad stuff, like Silk Road, the online drug website, was hosted on one of these hidden services. But there's also legitimate reasons to use hidden services. Let's say you're part of the Syrian resistance, and you want to create a website where people can communicate with each other and coordinate. Let's say you're part of the Egyptian resistance, or any one of these new, civil disobedience. You're a political dissident. You may want to use a hidden service to be able to give people information because you may live in a country where your internet is not freely accessible, and where there's strong censorship, and where you may get yourself in some real trouble if you are looking up information about, things you're not supposed to be looking up. So Freedom Hosting was a server that provided hosting services for hidden services. Now, Freedom Hosting had a lot of different websites on it. It had a very secure email program was hosted on it called Tormail, which was intended to be a very anonymous form of email. But unfortunately, Freedom Hosting also had a lot of child pornography stored on it, and it was used as a means of really putting a lot of child pornography websites on it. The feds were interested in shutting down and tracking down a lot of these child porn sites, and specifically going after the guy who created Freedom Hosting, who is this guy, Eric Marquez. And the fact that there's a picture of him can tell you that he got in trouble, because otherwise you wouldn't have seen a picture of him. But basically, what the feds did was in August of 2013, if you visited, for a period of days, if you visited a site that was hosted on Freedom Hosting, that could be a child pornography site, it could be any site, it could be Torment, again, just an email service. You started to get an error message. And that error message basically said the site you're trying to access is not accessible. Now, what was secretly hidden inside that error message was a piece of malware that ran on the person's computer, but didn't actually install itself on the computer. And what that malware was doing was basically de-anonymizing the people who were coming to the site that was hosted on Freedom Hosting. So if you remember, in order to get to one of these sites, these hidden services, you've got to use Tor. So you're making steps to hide your traces. What the FBI was able to do was they basically exploited a Firefox security hole that de-anonymized visitors to any site that was hosted on Freedom Hosting. As part of that, they were able, I mentioned Tormail, they were able to actually get all of the messages sitting on Tormail through this. And what ended up happening was they were relaying this information to the FBI headquarters in Virginia. They were ultimately able to figure out and kind of piece together where Marquez was hosting the, where his servers were located, where he was located. He was ultimately in Dublin, Ireland. He was arrested, and now he's awaiting extradition to the United States, and there's going to be a whole legal battle over what's going to come of it. But you can see the advancement of this FBI malware. And if you think about it, think about the fact that the malware was targeted and de-anonymized not only bad people who were trying to download child pornography, but anybody who visited a site hosted on the service. So the question then is, well, hold on a second. The Fourth Amendment says searches and seizures, which is basically taking possessory interest over an item, have to be particularized, okay? You have to target a specific person or a specific place. This is not that. This is generalized, right? This is a general warrant in a sense. They're putting this stuff on everybody's who's visiting the site's computer. And it's a very powerful tool that can do this. It's not just freedom hosting. In last year, in the Wall Street Journal reported on this, basically some of the new tools that the FBI has in order to track and locate people that they're interested in. The article, and you can read the article, but basically says the FBI develops hacking tools internally and purchases others from the private sector. So here's an issue, right? We've got, and I'm sure if you do anything in cyber, you hear about 0 days and the market and exploits and all this stuff, and companies that are selling, finding exploits on security websites or finding security holes and selling them to malicious governments. Well, guess what? Our government does it too. Okay? So that's the first thing. But what does some of this hacking tools do? Well, the Bureau can remotely activate the microphones and phones running Android. Okay? So if you're a suspect and they want to get information about you, the FBI has the capabilities to send malware to your cell phone. That cell phone will secretly activate your microphone and it will record conversations. Now, who are you going to be talking to? You're going to be talking to maybe your criminal co-conspirator, but maybe you're talking to your mom, right? Or maybe you're talking to your dad. Or maybe you're sitting in this class and you're hearing a lecture from some guy from the EFF and you have your cell phone in your pocket, maybe it's secretly recorded. Now, I don't mind because I don't mind being recorded. But perhaps when you get out of class, you're going to say, man, that guy Hanni, he was not interesting, that was boring, or whatever. And it's just they're capturing all. Okay? Here's another example. This was an example of the judge denying the request, and it got published in the news media. And let me tell you this one. If the news media is publishing the fact that a judge is denying the request, you can bet that's a pretty rare occurrence. Okay? That the reality is that there's probably a lot more requests that are being approved than denied. Well, what was the request that was here? Basically, the request was that after they deployed the payload, the FBI would be able to record keystrokes, read emails, and even take pictures from an attached webcam for a period of 30 days. Okay? So they hijacked the computer. And they hijacked it the way that a malicious actor would hijack your computer to steal your personal information, steal your credit card numbers, to harass and annoy people. We've heard cases of this where people are hacking into computers to harass women, tell them to take their clothes off and take pictures, do some really disgusting, awful things. Well, guess what? Our government's doing it too, okay? And, this judge said, no, I'm not going to let you do this. Now, they went and they asked for a search warrant. And the judge said, no, I'm going to let you do this because I think your requests are vague and they don't indicate how you're going to minimize the amount of irrelevant information you're going to collect. And again, it goes back to the problems of particularity. How do we make the request and how do we give the government tools to collect the information it needs in a way that minimizes kind of collateral damage, to borrow a term I don't really like, but it works, okay? So that's kind of one aspect of the problem. There's a second aspect of the problem that we haven't even touched upon that I want to spend a little bit of time on. And that is I want to jump back into the Fourth Amendment for a second, for a minute. We unfortunately have a doctrine under our Fourth Amendment law that says when you expose information to a third party, you surrender your expectation of privacy in that information. Now, that could be you expose it to the public in a small, discrete way. So, for example, there's a Supreme Court case that said, from the 1980s, that says police don't need a search warrant to install, to track a car's location with a beeper device. So if you think about a beeper device, it's like, the little red honing symbol, okay? In that case, the case is called United States versus Knox. The police basically followed this car as it made turns on public streets. And the Supreme Court said, well, you don't have an expectation of privacy in your public movement. If you think about it, it makes sense, okay? If I'm driving here on Pacific, and I make a left turn onto Franklin, I think it's Franklin, I expect that the person in the car next to me or the guy standing on the street across the street is going to see me make a left turn, right? I can live with that rule, that's fine. Well, guess what? The technology is changing, right? Now the technology allows the police to follow your movements for 30 days, right? They could install a GPS device, they could track a car for months. I've seen it in cases. They put the GPS device on the car, they follow the car for 6 months, they have a record of every place that car went. Or they go to the cell phone company. Everyone in here has probably got a cell phone, okay, AT&T or Verizon or whatever. That cell phone connects to the cell phone tower to make a phone call, right? Well, that cell phone company keeps a record of which cell phone tower you connect to. And police can go to the cell phone company and say, hey, give me Hanni's cell phone connection records for the last 6 months. And they would see every cell phone tower I connected to. And if you're like me, and you have a certain routine, they're going to see my routine. So for example, it'll say that at 8 o'clock in the morning, I connect to the cell phone tower that's right by my house. And then at 9 o'clock in the morning, I connect to the cell phone tower that's right by my work. And then at 6 o'clock at night, they're going to see that and you're going to follow my movements. They can see that, oh, he followed the path that he went to go back to his house. Or they'll see variations. If I don't go back to my house, but I go to a different location in a residential area in Berkeley, instead of out by my house out in Contra Costa County, and they see that I stay in one place for 10 hours, and then I move again at 8 o'clock in the morning, well, then they can figure out that I spent the night somewhere else, right? And as, smartphones take off, as everyone's, tweeting and Facebooking and Instagramming and doing all this stuff and creating more data connection points to the cell phone company, this data becomes more precise, because then you have more connection records, and as those data connections and that location information becomes more precise, then you have a more rich portrait of where a person moves. Well, believe it or not, the police are using this in all sorts of criminal cases. And the problem is the court said, well, you've turned that information over to a third party, so you don't have the expectation of privacy. Even though if I told you, would you think that every record of your movement for 6 months should remain private? You'd probably say, yeah, I think it should. I don't want someone to know where I've been every minute of every day for 6 months. The courts don't necessarily see it that way. I put this kind of like alphabet soup of logos because the reality is we live in a time where people are using the internet for cloud storage, right? Everyone stores their emails in their inboxes forever. People are putting pictures of their kids on Facebook. People communicate over Twitter, whatever it may be. We are giving all of this information over to third parties. And the problem is the law from 1976, and actually that's a typo, I should say 79. The law said the court said in 1979 that, well, you don't have expectation of privacy and information you turn over to third parties. And that's now being extended to cover very different forms of information than existed in the 1970s. Now, Congress tried to fix this. They anticipated that this could potentially be a problem. And so they've crafted some rules that were intended to kind of fill this gap. But what you'll see is that the gap is not filled at all. Let me walk you through it, very kind of 30,000 feet level, very broad. Basically, there are 3 statutory pieces of protection that really govern electronic communication records, and that are relevant in any discussion about cyber. So the first is the Wiretap Act, okay? Wiretap. You ever watched the TV show The Wire? Okay, and they were listening to Stringer Bell's phone calls, right? That's what we mean by the wire. It governs the ability of law enforcement to intercept communications. Those communications could be wire through a telephone, like a landline. They could be oral, meaning you and I are having a conversation, and if the police want to secretly record it, you notice you asked me if you minded if I recorded. That's because if I don't, in California is a 2-party consent state. I have to consent to being recorded audio. Now, you don't actually need my consent because I have no expectation of privacy in a room with 40 people, but maybe that's an open issue, right? So the Wiretap Act covers that. And it also covers electronic communications, okay? So if you communicate over email or instant message or Twitter or whatever, you are protected under the Wiretap Act, which generally has some pretty stringent requirements that the government has to meet. And if the government doesn't meet those requirements, they can't use the communications that they've intercepted. Now, but there's one problem. Problem is, the part of the law that says the government cannot use communications that are illegally intercepted only applies to wire communication and oral communications. It does not apply to electronic communications. And the reality is, we have lots and lots of electronic communications. Even our phone calls, if you use a VoIP phone, okay, that's a very popular, cheaper way to make your phone calls. That's an electronic communication, that's not necessarily a wire communication. And you're gonna end up having problems of fitting under the Wiretap Act, okay? In 1986, Congress passed what's called the Stored Communications Act. And this is designed to kind of deal with that third-party doctrine. It's designed to fill the gap and provide legal protection for communication records that are stored electronically online with a communications provider like Google or Facebook or whoever. And then the way the Stored Communications Act works, and again, I don't want to bore you with the law, but it's important to kind of understand these very general principles about it. The way the Stored Communications Act works, it says basically, okay, there are really three categories of information that a storage provider has and that law enforcement can get access to. The first is the contents of your communications. That's like your email body. Hey, let's meet at this building for lunch at 3 o'clock, okay? The second is kind of all of the routing and detail information about how you communicate. So that could be your email header, like from, to, date. It also includes the metadata that you don't typically see, but shows which IP address the message is coming from or going from. And then the third category of information is what's called subscriber information. This is basically your account profile. You have a cell phone through AT&T, you opened an account, they have your address, maybe you do bill pay, and they have your credit card number. That's subscriber information. What Congress basically said was, well, the provider is not allowed to disclose the contents of communications to anybody, except in certain limited circumstances. And one of those circumstances is to the government. But all the other records can be disclosed. And then they said law enforcement can get access to the contents of the communications if they meet certain legal requirements. And one of those requirements is that they get a search warrant. But as you'll see, the way they wrote the law doesn't really actually protect email with a search warrant requirement. We'll get into that in a second. The final piece of this puzzle is in 1986, Congress also passed the Pen Register Act. I'm not going to spend a lot of time on it, but basically what a pen register does is it collects electronic and wire dialing and routing information. That's basically the list of phone numbers you dial, the list of phone numbers that dial you. If you're thinking about a landline, if you're thinking about the internet, that's really where your communications are coming from, the IP address, etc. When I said that Congress didn't craft this law well, and they didn't future-proof this law, let me explain what I mean. The warrant requirement in the Stored Communications Act only applies for messages that are unopened in electronic storage for less than 180 days. What the hell does that mean? Let me walk you through it. And then before I walk you through it, let me explain what Congress's mindset was when they passed this law in 1986. Raise your hand if you had an email address in 1986. One person. Raise your hand if you have an email address today. Everybody, right? Okay. I was 4 years old in 1986. I didn't have that. Okay? In 1986, how big was your inbox? It was probably what? A byte? 2 bytes?
Oh no, that's the way I went off email for a while.
Right.
It was hundreds.
Okay, so hundreds of bytes, right? Now, if you have a Gmail, I have a Gmail, I have, 1 billion gigabytes. That's an exaggeration, but that's what it feels like. I have so much storage space I can throw all my messages in there. But back in 1986, people didn't keep a lot of messages on their server. What they did was you would log into your email maybe every week or 2 weeks, I don't know. You would see your messages. You would download the important ones onto your computer because you wanted to keep them in a safe place like a computer. And that's if you had a computer. Most people in 1986 didn't have a computer. You would keep your messages on your computer. And the thought was if you had left messages on the server for more than 6 months, you'd effectively abandon them. And if you'd abandoned them, then they weren't entitled to legal protection. That's what Congress's mindset was. And maybe that made sense in 1986. Today it's 2014, so it's almost 30 years later. But how do people use their email now? They use it in the exact opposite way. Nobody keeps their email on their computer. Everybody keeps their email on the server because you have infinite storage space. And if I have my messages on my server, that means I can get my email in real time on my iPad and on my iPhone and on my laptop, and I can search it when I'm in Estonia or Turkey. I can search it when I'm in Monterey or in San Francisco. I have access to it everywhere. And if you think about the way the web has developed, you hear about the push to go put everything on the cloud. You see Google has these new Chromebooks, right? These are laptops that don't even have hard drives in them. They don't have real operating systems. They're just designed to get you on the cloud. You keep everything on the cloud. You get on an airplane, you can get Wi-Fi. This is the new world we live in. The legal protection hasn't kept up. And so you end up with this crazy way in which the law is intended to protect email. And I'm just talking about email. I'm not even talking about other stuff. And you can see it just makes no sense, right? It's outdated. It's obsolete. Well, you know, thankfully, the companies have basically said, you know what, we're going to make it simple. We're requiring a search warrant to get the contents of communications, period. And like I mentioned, that's because in 2010, one federal appeals court in Ohio, the Sixth Circuit Court of Appeals, basically said people have a reasonable expectation of privacy in email messages, and therefore police have to get a search warrant to get them. And basically, most of the providers, as a matter of practice, have decided that they're going to basically get their, they're going to make a warrant requirement the law. But even if you get to the warrant requirement, there are still obstacles. This was in the New York Times last week, okay? And remember, like I said, if you have newspaper articles, major newspaper articles like the New York Times and Washington Post and Wall Street Journal, writing stories about judges denying requests, you can bet that this is a rare occurrence. So in this case, this is from the New York Times last week, magistrate judge in DC basically denied the government's request for a search warrant to search for emails. And basically, here was what this is from the article, but it puts a little bit of an order. Basically, the judge was mad that the government wanted every single email in the email account of the suspect email account they wanted to get. And they wanted to look through. And basically, this is the quote from the judge. The government continues to ask for all electronically stored information in email accounts, irrespective of the relevance to the investigation. And this is what the judge didn't like. And this again goes back to the problem. How do you make a computer search particular? How do you do that? The government says, judge, look, this guy this was like a kickback, fraudulent wire fraud type case. Said, we have probable cause that this guy is using email and communications in there that are going to prove our case. And they said, judge said, look, you can get it, but you can't get all of the messages. You're going to have to come up with a way to narrow it. And the courts have not really dealt with this. And the reason this is important in the world of cyber is you see this kind of approach of taking everything and kind of sifting through it. It's what's at issue in the NSA cases. And again, I'm not going to talk about the NSA stuff, but that's the mindset. There's too much stuff, let's collect it all, and then we'll sift through it later. I'll give you a domestic example. Has anybody heard of Lavabit? Okay, a couple people heard of Lavabit. Lavabit is a secure email provider. Basically, you paid for the service, so it's not like Gmail, but the way it worked, it was basically had very strong encryption, so that the messages were encrypted when you sent and received them, the messages were encrypted when they sat on the server, and really the company had no way to decrypt specific messages as they came in, okay? Well, a certain Edward Snowden, presumably, or was thought to have used Lavabit to send an email, and unsurprisingly, once that became public, the U.S. Attorney's Office in the Eastern District of Virginia sent a request to Lavabit asking for certain communication records of a particular user. They won't say who the user is. We suspect it's Edward Snowden, but we don't know for sure. And basically what Lavabit said was, well, look, you know, we can't, he basically said, I don't have a mechanism. I have not configured my system in a way to give you the information you want unless you get my private SSL key, which would basically unencrypt all of the communications I have sitting on my server. And so the government said, okay, we'll take that. And he said, well, I don't really want to give you that because that's going to undermine my business and it's going to put all my customers' records at jeopardy. And basically the government said, well, too bad. You give us your SSL key and then we'll be done with it. The reason Lavabit got put in this situation is, again, the law hasn't kept up. In 1994, Congress passed a law called CALEA. It's basically the communications assistance for law enforcement something. I can't remember exactly what. But what basically CALEA says is that telcos, not ISPs, but telcos, have to configure their architecture. They have to configure their system to allow the government to install a wiretap or to install a pen register device. Basically, if you're AT&T or Verizon, you have to create a system by which the government can get access to communication records in real time. When CALEA was passed in 1994, it explicitly excluded internet service providers. So internet service providers, like Lobabit, don't have an obligation to configure their systems in a way that facilitates access to the government. They certainly have to comply with orders, but they don't have to create a system by which they can comply. And Lobabit's defense was, well, we don't have the system set up in place, and the only thing I can do is give you the SSL key, and I don't want to give it to you because that's like giving you a key to all of my communications. Well, what happened? The judge said, nah, you got to give them the key. The case is now up on appeal in the Fourth Circuit. But ultimately, it put the private communications data of over 400,000 customers at risk because the government wants one person's records. Lobabit ended up shutting down their emails. He shut down the company. It's one guy who ran the company. He shut it down and said, I gave them the key and I'm shutting down my company. I don't want other people to use my service because it's now compromised. And so you see a business made money, didn't make a ton of money. It's not a huge business, it's got 400,000 users. That's nothing compared to Gmail, but we see now the company completely forced to shut down because the government wants and wants and wants and wants and wants. Now, what's the end result of this system we've created where it's easy to facilitate government access to these sorts of records? Well, this is from the Google Transparency Report. Wow, that's really hard to see the light blue. But basically, it's an upward slope. Google keeps a record of how many requests are given or sent to Google by government for information about a user account. And this is in 6-month increments. So it's doubled, okay, since 2009. And it's going to go up every year. And all of the major companies have similar reports, and they all have the same trend. Twitter, Facebook, every year the number of requests are going up. Verizon, AT&T, every year the number of requests are going up. And I add this one last thing before we shift to prosecution to say, look, we've talked about government snooping and government looking at your communications records and the problems with that, but it's not just the government. Last week USA Today reported about this. This was a case where Microsoft had an ex-employee who they believed was leaking trade secrets to a blogger. And so what did Microsoft do? The blogger just happened to have a Hotmail account, and they searched through the guy's Hotmail account. Okay? Now you're probably thinking, wait a second, how could they possibly do that? Well, the Stored Communications Act says a provider can't disclose the contents of communications to anyone except for under certain exceptions. Well, one of those exceptions is if the user consents. Well, guess what? Anybody here have a Gmail or Hotmail or Yahoo Mail account? Because if you do, you've consented. You consented when you signed up for the service, and there was that huge block of legal text that you didn't read, and you scrolled all the way to the bottom and said, just give me my free service. I don't care what this thing says. But what that thing said was, guess what? If we believe we think you're violating our terms of service, we reserve the right to look through your content. Okay? What does Microsoft's terms of service say violates their terms of service to which they can review your content? Well, how about you send links to a website that violates that terms of service, and it's a violation of the terms of service of Hotmail to send links to websites depicting nudity, okay? So if you send a link to the Wikipedia article on genitalia in your Hotmail, okay, you are violation of their terms of service, and they can search through your email. Are they going to likely to do that? I would have said no, but
yeah.
Okay, this was about an IP dispute. This was a trade secret dispute. They looked through the guy's messages and they turned it over to the FBI. So this is the reality we live in. This is how we've seen this failure to connect with the reality of what is going on in the internet, with how laws that were intended to protect us utterly fail to protect us because they haven't been updated. And then what we end up seeing is as we talk about the way prosecution happens, we see what the reality is. We see the government has easier access into these records, okay, than they did before. And then they are using that access to bring crimes and to bring cases that are really threatening, civil liberties rights. So let's shift, now that we've kind of identified the problem of the law keeping up in the investigation side, let's talk a little bit about prosecution. And really when I talk about prosecution, the one piece of law I'm going to focus on is the CFAA. The CFAA is the Computer Fraud and Abuse Act. It's a federal crime. It's a federal criminal statute that was written in 1984. Now I put picture here of War Games, the movie War Games. Has anybody seen the movie War Games? Matthew Broderick from 1984. And in the movie, basically, Broderick, this is before he was Ferris Bueller, he was a hacker. And he basically hacks into this like military computer, and he accidentally sets off a nuclear conflict, and everyone's freaking out that he's going to start World War III just because he thought he was playing a game, and it turns out he wasn't. He's actually, caused some damage. So in 1984, when Congress was going to have hearings about this new bill, they said, before we start our hearing on the bill, we're going to take a couple minutes to show a clip from this film that highlights the problem we're trying to deal with. And then they showed some clips from War Games. And now what ended up happening was Congress passed the law in 1984, and what the Computer Fraud and Abuse Act does, it's a very long statute, but in a nutshell, what it does is it punishes anyone who accesses a computer without authorization or in excess of authorized access. Now, the problem, and there are many problems with the CFAA, but one of the big problems is the CFAA doesn't actually define what these terms mean, right? It defines without authorization, but it doesn't define exceeds authorized access. And the real issue is, what does it mean to be authorized and what does it mean to have access? Now, when Congress passed this law in the 1980s, they were talking about people who are malicious hackers, who break into computer systems, who steal money, who cause damage, and do mischief and mayhem. The problem is that because the law is vague, and it was broad, and it was poorly written, you end up in a situation where there's a lot of potential for abuse. So let me talk about 3 specific problems and how this is manifested. And then I'm going to show you case study after case study after case study about the problems with this law. So 3 problems. First, private agreements and duties can define the scope of liability. I just mentioned about Hotmail's terms of service. And I mentioned how they reserve the right to search through your email if you are in violation of their terms of service. There are court cases that have said you are exceeding your authorized access, or you are acting without authorization if you use a website in violation of the terms of service of that website. Now, the CFAA, the base point for the CFAA, it starts out as a misdemeanor crime. So it's not a very serious crime, it's a misdemeanor. And the misdemeanor crime says if you exceed, if you act without authorization or exceed authorized access and obtain information, you're guilty of the misdemeanor. To obtain information simply means viewing text on a website, okay? So right then and there, you violated terms of service, you are guilty of the misdemeanor violation of the CFAA. So if you have a Facebook account and it says put the city of your residence and you put that you live in Monterey, but you actually live in Marina, and you're in violation of Facebook's terms of service, and under the CFAA you are not guilty of a misdemeanor, okay? Now, you can get felony liability if you cause damage, you take $5,000 worth of stuff, you are committed, you violate the CFAA in furtherance of another crime. But the real problem is you end up having the ability of private agreements and duties to define what is and is not a crime. The other thing to note about the CFAA is it's not just a criminal statute, it's also a civil statute. That means you can bring a lawsuit against a competitor or a person or an ex-employee or whoever under the CFAA. And so when you look at CFAA case law, there's both civil cases and there's actually a lot more civil cases than criminal cases. But the decisions that are being handed down in civil cases apply just as forcefully in criminal cases. So you end up with a scenario which is kind of unique in criminal law, where you have private parties are dictating what is and is not the criminal law. We've delegated that task to Congress to do that, not to private parties. And yet this system kind of circumvents it. Speaking of circumvention, another problem with the CFAA is that innovative access can be criminal. I think the best way to think about this is to give you an example from a case we worked on called Craigslist versus 3Taps. Anyone ever used Craigslist before? Okay. Who's used Craigslist to look for an apartment? Okay. Who's enjoyed that experience? It sucks, right? Because looking at Craigslist is stuck in 1995 on its website, right? The links are all, it's purple overload, right? And so there was a company called 3Taps. And what 3Taps did was it said, okay, we're going to take the Craigslist apartment ads and then we're going to lay them on top of a Google map so that instead of searching through Craigslist listings of, just a blanket list of listings and you got to sift through them, you can actually put in a specific address or look for a certain neighborhood and try to decide, oh, that apartment looks good or this apartment looks good because it's on this side of the street or it's in this neighborhood of town. Well, Craigslist didn't like that. And Craigslist sued 3 taps under the CFAA, and their theory was, what 3 taps said was, where's the unauthorized access? Your website's accessible to anybody in the world. You don't need a username and password to log in. I can just go to Craigslist and look at the listings, and I could have written them down with a pen and a paper, and I could have taken a big map, and I could have plotted it out on a map, and I would not have been in trouble. Just because I'm doing that with technology doesn't mean that I'm guilty. Well, Craigslist said, well, yes, it's true that our website is open to the public, but we revoked your access specifically because A, we sent you a cease and desist letter to stop using our data, and second, we attempted to block your IP address from logging into our website. So that was the theory by which Craigslist stated a CFAA claim. Now, keep in mind, it is not criminal to use that data, right? And it's not criminal for 3 taps to basically ignore the cease and desist letter. It's not criminal for them to try to work around that IP block so they can get access to the data. But that was enough to state a CFAA claim. And so now you have a situation where a website can make a unilateral decision about who's authorized to view the site and who's not authorized to view the site. And websites do that all the time, but traditionally that's been done through a username and password, right? If you have a username and you have a password and you log into the site, you're allowed to see the site. If you don't have a username and you don't have a password, you're not allowed to view the site. Well, Craigslist found a way to kind of bypass that for its site, which is open to the public. And now the problem is, so now 3 taps is on the hook civilly for money damages, but the issue is a person who does this in a criminal context is now in criminal trouble. The third problem with the CFAA is it has a very significant and disproportionate penalty scheme. And we're going to talk a lot about this because I think this gets to the root of the problem in terms of thinking how this country approaches cyber issues. Federal crime, there's a saying about making a federal case out of it. And the idea is that federal crimes are supposed to really be the bad stuff, like wire fraud, big drug cases, gun distribution rings, child pornography. Really, the states deal with criminal laws and crimes, and the feds really kind of take the big stuff on. But what you see with the CFA is trivial things get blown up into federal cases, then they get blown up into felony cases, and then the amount of punishment you're looking at is huge. Right now, we're in a cyber panic in this country where we are freaked out about Anonymous and LulzSec and all this stuff, and you see the responses that anytime there's a guy that gets a CFAA charge, they're out with their knives sharpened. Let's talk about a couple of these people. Aaron Schwartz. I think everybody here knows who Aaron Schwartz is. Unfortunately, committed suicide. He was a friend of the EFF. Now, he was charged under the CFAA for downloading JSTOR articles, which are publicly generated articles that are, you can download, you pay money to download them. But the thing that's tricky about Aaron's case was at the time he downloaded so what he did was you're allowed to download an article or 2 from JSTOR. What he did is he tried to bulk download the entire JSTOR repository of documents. And he did this at MIT, where he was kind of loosely affiliated. MIT has an open access policy, meaning if you're on the MIT campus, anybody can access any of the files or records that MIT is otherwise entitled to access. So what that ultimately means is he was actually allowed to have the documents. He just couldn't have them in the way he was trying to get them. The government charged him with CFAA, they charged him with wire fraud. There's a lot of hyperbole about how much time he was looking at. If you read some news reports, 35 years, 50 years. I'm not going to bore you to death with the details. He wasn't looking at 35 or 50 years. Realistically, he was looking at a few years in prison, 4, 5, or 6 years in prison. He was offered a deal for a few months in prison. Now you tell me, where's the crime here? Was this guy worthy of a few months in jail for taking documents from JSTOR that he was otherwise entitled to access? I'm not saying that what he did was squeaky clean and shouldn't, be examined. But the question was, does this punishment fit the crime? And he committed suicide. It prompted a big outcry. It prompted reform efforts. It kind of stalled a little bit. It's been over a year now since he passed away. But his case, he was kind of like the poster boy for this. The next couple guys I'm going to introduce you to aren't really at that same kind of hallowed level as him, but they still show some of the problems. I'll talk about one of my clients, Weave, or Andrew Arnheimer. Weave is basically, he's now in jail, and let me kind of walk through what he got in trouble for. He got convicted under the CFAA because of something that his co-defendant did. Basically, his co-defendant, if you remember back in 2010, when the iPad first came out, AT&T had an exclusive agreement with Apple to basically sell 3G connected iPads. So if you wanted a 3G connected iPad, you had to get it through AT&T. And what AT&T did was when you bought your iPad that was 3G connected, they put a SIM card in your iPad so that you could have 3G access, and they tied that SIM card to your email address that you had associated with your AT&T user account. What they then did was they configured their website so that when you went to the AT&T website on your iPad, because they were linked, your email address and the serial number on the iPad 3G SIM card were linked. When you went to the website to go log into your account, your email address would already be filled in, and the username portion. Now, before I go any further, that's a really stupid thing. It's a really stupid way to configure your security, but that's what they did. Auernheimer's co-defendant, Spittler, what he figured out was that AT&T had put the ICC ID number, so the serial number, they put that serial number in the URL that you would go to visit the website, okay? Note to self, this is a stupid way to design, your system, but nonetheless. So what Spittler realized was, well, if I just keep increasing the numbers of the serial number, okay, it's a 17-digit number, so if he started with 111111 and so on, he would get an email address. And then if he changed it to 11112, he'd get a different email address. And then he changed it to 111113, he'd get a different email address. And so on and so on and so on. So he wrote a script. And the script would just change the numbers of the ICC ID number. 120,000 email addresses later, okay, they had this big pot of email addresses. Auernheimer then gave those email addresses to Gawker, the website, and Gawker ran a story that said, hey, look at AT&T's really stupid security system. What was the result of it? Well, he was charged under the CFAA. And the idea was that he had obtained unauthorized access to these ICC ID numbers. And I should note that his case was just argued on appeal last week, and I was out in Philadelphia for the oral argument. And at one point during the oral argument, and again, this exemplifies the problem, the prosecutor who has prosecuted this case, who has filed an appeal in front of the Court of Appeals, told the Court of Appeals, you know, judges, I don't even really understand what Mr. Auernheimer and Mr. Spittler did. I don't understand the technical details of it. But it was enough to get Mr. Auernheimer 41 months in prison, okay? So we have a situation where we have poorly designed technology. We have Mr. Auernheimer. If you do any Googling of him, you'll find he's not the nicest guy in the world, as some people will say. I actually think he's a very nice guy, but he can be kind of he's an interesting character. Interesting character. And he gave it to Gawker. He didn't go tell AT&T. So there's some bad atmospherics there. I admit that. But the issue is the real problem was they couldn't. There's a misunderstanding of the technology, and the misunderstanding of the technology landed in 41 months. The misunderstanding of the technology is what happened here, where there wasn't an appreciation for the fact that he was entitled to access these documents, but came up with a creative way to do it. And I should note about Aaron Schwartz real quick that he had gotten the attention of the feds before, because in the federal court system, all the court records are filed electronically online through a system called PACER, but the federal government charges 8 or 10 cents a page to access the documents. And these are, this is taxpayer-funded documents that are being, these are public records. You shouldn't have to pay to get public records, is what his mindset was, and he basically liberated a large number of documents out of the federal court system, and that made the federal government very upset. And so he had already drawn their attention before. Again, an idea to liberate the documents. Jeremy Hammond, this guy, he's a politically motivated hacktivist, okay? He hacked into the servers of Stratfor, which is a defense contractor, and he basically obtained thousands of internal emails and credit card numbers. The emails showed all sorts of stuff that Stratfor was engaged in, I don't know what the right word to say is, but reputation espionage, maybe is one way to say it, and at the behest of private companies and other governments, including the United States government. And look, it's pretty clear he broke the law. He shouldn't have hacked into the servers. There's no question about that. But then the issue was, at his sentencing, was what type of sentence should he receive? Now, Hammond has a prior record. and he had prior convictions under the CFA. And he was pretty unrepentant about what he'd done. And he basically said, look, I'm an activist, I'm a believer in political change through activism, and I'm not sorry for what I did. You know, what I did was expose uncomfortable truths about power, about government, clearly politically motivated. Again, doesn't justify that he, you know, I'm not saying that's a whitewash of why he broke the law or not, but that is the underlying kind of background to that, or backdrop to that. And he got a 10-year prison sentence. Now, 10 years, maybe you're thinking, well, you know, emails and credit card numbers, that's a lot. The important thing to note, so this case is prosecuted in Manhattan. We wrote a letter on behalf of Mr. Hammond telling the court, don't give him 10 years, give him a shorter sentence. And when I was doing my research for this letter, I found a case where the prosecutors in Manhattan, federal prosecutors, same courthouse, basically was able to convince a judge to give a guy 10 years in prison in a $100 million Medicare fraud case, right? Which I think that seems pretty fair, you know. Medicare fraud series, that's a lot of money, it's a lot of fraud, $10 million, you know, $100 million, and you got 10 years for it. But Mr. Hammond got 10 years also, and it shows you kind of the disproportionate impact that this law has. And I would note that Hammond actually had co-defendants in the UK who got charged in the UK courts, and there's 4 of them, and their sentences ranged from the most lenient sentence was 200 hours of community service, and the most strict sentence was 32 months in prison for a guy who had a prior record. And he only served, I think, a third or a quarter of that sentence. But Hammond got 10 years because he was in the United States, and we have the CFA. Barrett Brown is another example of this. He was a journalist who's been published in Vanity Fair, Huffington Post, and The Guardian. And basically, when Hammond got these documents from Stratford, what happened was Hammond or someone else basically took those documents, uploaded them into a cloud-based server where anyone could access the documents. Barrett, who was a journalist who was going through these documents, took the link to those documents and copy and pasted it from one IRC chat room to another IRC chat room. And ultimately what ended up happening to Barrett, now there's a lot more story with Barrett Brown, including the fact that he was a heroin addict, he claimed he was a spokesman for Anonymous at one point, and as the feds are kind of investigating him, he made a video where he allegedly threatened to kill the FBI agent. So there's a lot of bad facts here. I'm not trying to whitewash it, I'm being upfront about it. But most importantly was, he was charged with obstruction of justice, charged with threatening the FBI agent. I'm not here to comment on that. He was also charged with transferring the credit card numbers and the aggravated identity theft for simply copying and pasting the link. Now, the aggravated identity theft charge, he was charged with 10 of them, 10 aggravated identity theft charges. And what's really scary about that is the way the federal aggravated identity theft statute is written, each charge is punishable by 2 years in prison, mandatory, consecutive to any other sentence, meaning if you get 6 months on the transferring the credit card numbers, the judge has to give 2 years to run after those 6 months are up. You get 10 counts of them, so potentially 20 years in prison for sharing the link, for copy and pasting a link to illicit material. Now, we have a First Amendment that says freedom of the press, and that the press is allowed to publish materials that are illicitly obtained as long as they didn't obtain it illegally themselves. And so that's why the New York Times can put every Snowden release, they can put the document, the slide, okay, and without fear of repercussion, because they're not the ones who broke the law to get those records. Mr. Snowden did, okay, allegedly. And but the New York Times is not going to get in trouble for publishing them because it has a First Amendment right to do so. So the argument was, well, Barrett did too. He had a First Amendment right to publish and post those documents for other people to share. Ultimately, the government dropped these charges, the credit card theft and the aggravated identity theft charges, after 18 months. He still got the other charges pending against him. But maybe they recognized that there were some real significant First Amendment problems and that their theory was inconsistent with how the news media has traditionally treated sensitive documents they're not allowed to have or that have been illegally obtained. Here's another one, Chelsea Manning. And he was charged with, or she was charged rather with CFAA and aiding the enemy for leaking 700,000 government documents to WikiLeaks. Again, I'm not saying that she should have, she shouldn't have, that she's not in trouble for stealing the documents, okay? I don't quibble with that. But the issue again is punishment. Aiding the enemy, that's the Espionage Act, okay? That's punishable by life in prison or the death penalty. Now, the government didn't seek the death penalty in her case, but they did seek to put her away life in prison. And the aiding the enemy charge, the theory behind it was that by posting the documents on WikiLeaks, and the documents were State Department cables as well as documents that highlighted real embarrassing stuff about how the United States was conducting its war in Afghanistan and Iraq at the time in the early 2000s, that they were basically giving Al-Qaeda and other terrorist organizations insight into how the United States was operating, and that embarrassment and damage could aid the enemy in this context. Now, ultimately, she was acquitted on aiding the enemy but convicted of other charges and got 35 years in prison under the CFA as well as the other charges. And again, it's encouraging that the court, it was the court who did not find her guilty on the aiding the enemy, but the thing is the government went through the theory and went through the process of prosecuting her under this theory, and it's a very dangerous theory. The last case, this is the last case that I'm just about finished, but is the case of Matthew Keys. Matthew Keys, he was he worked for he worked for the local news agency up in Sacramento, basically like the local TV station. And that station was owned by the Tribune Company, so like the LA Times, Chicago Tribune. And what he did was he gave a username and password of their content management system. He basically he left it in a IRC chat room that had some anons in it. And those anons, what they did was they went to the LA Times website and they changed an article. So they changed the headline of the article that says, to say, pressure builds in House to pass tax cut packages to pressure builds in House to elect Chippy 1337, okay? It's a prank, it's vandalism, it's pretty stupid. It's a crime to commit vandalism, okay? Now, the issue is, in California, so he was in Sacramento. In California, vandalism, like spray painting graffiti on a street sign, okay? It's a wobbler. A wobbler means it can be punished as a felony, it can be punished as a misdemeanor, you can get probation for it. You're not likely to see a felony vandalism case unless you do something really dramatic. Like you go and you take a baseball bat and you break, destroy someone's car, okay? But like spray painting graffiti, you're not, you're gonna end up cleaning up trash on the side of the freeway, okay? He wasn't charged in the California State Court with vandalism. He was charged with CFA. And he's looking at, maybe 2 years in prison under the CFA for this act, right? And, and part of it was the Tribune Company said they paid like $20,000 to fix the damage, which was to fix this website, but also to secure their system and reset their passwords, okay? Ultimately, what all of this kind of goes to, and I'm going to wrap up here and then take questions, is it shows that we have some problems. We have problems with the way our laws are being applied to technology. And, those problems are A, overly broad searches. The government's authority to search has never been greater than before. And the amount of information at their disposal has never been greater than before. And these broad searches are broad in the sense that they violate the principles of particularity, meaning they are not pinpointed towards a specific person. And they're broad in the sense that they're not only capturing a huge amount of information about that specific suspect, but they're also capturing a huge amount of information about everyone that suspect communicates with. So if the government wants to use a search warrant to search through someone's email, they're necessarily getting all the other emails in that inbox. And if you've ever communicated with someone, who gets arrested for something or is a suspect in a case, then your records are looked at and scrutinized too. So this is the Fourth Amendment was designed to prohibit this sort of broad search. And at this day and age, with our technological realities, it's hard to keep up with that. And so that kind of touches on my second point, which is that too many innocent people are touched. We see this in the NSA context. The NSA's approach is collect all, sort through later. Well, collect all means collect everybody in this room's phone metadata, collect everybody in the city of Monterey's phone metadata, collect everybody in the entire United States' phone metadata, meaning that you now are a suspect and you have to have your records sifted through and cleared to make sure you're not a terrorist or affiliated with, someone who's on their list, which could be an arbitrary decision if you make the list with We have too much data that falls under the third-party doctrine and is falling outside of legal protection. I showed you the crazy table about the emails. The law is outdated, but we are living in an increasingly digital age where people are communicating and storing information online, where that information reveals a whole lot about us, which social services we use, which pictures we put on Instagram, who our friends are on Facebook and Twitter, say a lot about who we are, and too much of it is falling outside of legal protection. I think one of the really interesting things is that this idea of excessive punishment as a means of deterrence is utterly failing in dealing with cyber crime. Now, the examples I put up, Manning, Keyes, Hammond, Schwartz, these are all cases that were brought under the CFAA or affiliated cases. And what we're seeing right now, like I mentioned, we have a cyber panic in this country. We have a fear of anonymous. We have a fear of the havoc that the internet can cause, the ability of the internet to spread information far and wide. And the issue is that we are taking the approach of, well, we're going to throw the book at people. We're going to increase the punishment. Congress has amended the CFAA many times, and each time it has increased penalties and created broader categories of information that fall under the law. And the end result is, I question whether it actually is having a deterrent effect. Because all of those actors I put up there, Manning, Weave, Hammond, Schwartz, to a large extent, these people are not motivated by greed. They're not motivated by trying to get rich, trying to hurt people. They're motivated by transparency, by revealing uncomfortable truths about how our government wields its power. I'm not saying that is a defense to the means they use in which to get their message across. And civil disobedience requires disobedience. It is criminal. It was criminal at the civil rights movement to chain yourself to the door. It was a crime to sit at the non-segregated lunch counter. And those people who engaged in those acts did so with a deliberate choice, knowing that they would be punished. And it's the same situation here, where people are deliberately engaging in acts of disobedience intended to prove a broader point for morality reasons. But the question is 10 years in prison too much time for someone who is being motivated by political purposes? And that's a question, and that's a conversation that we are not having in this country. We are having conversations where we see, well, Target just got 40 million credit card numbers breached, so therefore the solution is we're going to jack up everything in the CFA and increase the penalties. And hey, I'm all for getting the Target guy. I shop at Target all the time. I'm freaked out. My credit card information is compromised. I hope they get it. But the issue is, what about everybody else? What about people who aren't motivated by these things? And ultimately, I think there's a failure to comprehend. There's a failure to comprehend that, like I said before, the internet is a democratizing force, and it works in the ways of shedding light on government abuses. And if you don't believe me, look at this guy, okay? Now, I'm not here to have the debate of, is he a patriot, a whistleblower, forget all that. But let's just talk about the means he did, and did they have the intended purpose? Okay. The first document that was leaked by Snowden, that was reported in the press, in The Guardian, on June 5th, 2013, was the phone records metadata collection program. This was the first leak. And what that leak said was, the government collects, in bulk, all phone metadata records from Verizon and presumably other providers. Okay, that was the first leak. What happened? I don't know if you guys have read the news today. What happened today? President Obama introduced legislation that is designed to stop this program. Why did he do that? Because as soon as this information became public, everybody got in a tizzy. And people got mad, and there was debate and discourse on it, and people could have differing opinions about whether the program works or doesn't work. But once it got the light of day, and people got upset about it, you now see a congressional proposal by the president to discontinue the program. So, in a sense, whether you think he's right or wrong, it worked, okay? And as long as it works, and the reason it works is because once The Guardian put that story on its web, it got shared 1 billion times, and once the next leak came out, and the next leak came out, and the next, it builds a group, and you can plot out the agencies and the programs, and you can do all of this stuff because of the technology. Once it works, there will be others who are coming to do the same thing. And if we don't address the root problems, like transparency, our moral hypocrisy in the world on certain issues, whether we are allowing technology capabilities to erode our civil liberties, if we don't address these root problems, you're not going to stop seeing people like Mr. Snowden. And so ultimately, our solutions are simple. We got to bring the Fourth Amendment into the 21st century. The way to do that is through litigation, through the courts, through explaining to courts the technology. That's something EFF does. We explain to courts what the technology is, explain the implications of technology, explain it's not just metadata, that people do have an expectation of privacy in their aggregated public movements. Okay? Obviously, there needs to be an update of federal and state electronic privacy statutes. Post-Snowden, there's actually been a lot of work in this ground. California, for example, has added a bunch of bills. Would bring a warrant requirement for emails, a warrant requirement for location privacy information. They've passed through the legislature. Governor Brown has vetoed them, but we're seeing other states take those same types of approaches. We need to reform the CFAA. We need to bring the penalties down. We need to really create a statute that's narrow, that really goes after malicious actors who are stealing information, who are using the CFAA, hacking into sensitive government computers, causing real damage. And then finally, we need more nuanced punishment. Political motivation has to be part of the equation. Again, it doesn't mean you get a free pass. It just means that 10 years, 35 years is too much time. There has to be punishment. I don't disagree with that, but we have to recalibrate what we're thinking. Right now in this country, in a completely unrelated area, we're starting to see this kind of idea of more nuanced punishment. We're seeing it in the war on drugs. For a long time, our country engaged in a war on drugs, and part of that war on drugs is we decided that we were going to punish crack cocaine more harshly than we were going to punish powder cocaine. And the idea was, well, crack cocaine is affiliated with urban areas, there's more violence in urban areas. If we go really harsh on crack compared to powder, we're going to create a better result. Well, 30 years later, it didn't do a damn thing. And now we're starting to see, Congress reduce the ratio. It used to be a 100-to-1 ratio, but it took 100 times the amount of powder cocaine to get the same punishment as crack cocaine. So this had a huge disproportionate impact on minorities, on people in urban ghettos, poor people. So we started to see the scaling back. We saw the ratio was dropped. It's now, I think, 28-to-1. We've seen President Obama has pardoned people, so like the more egregious cases of defendants who spent 20, 25 years in prison for simple drug crimes. We've seen a recalibration of this. We've seen more drug courts. We've seen more approaches to deal with the poverty at issue and the underlying problems that cause people to go into drug abuse. We need to have the same sort of approach with how we handle cyber. We have to stop thinking of it as a terrorism problem. We have to stop thinking about it as a unique, new era. I mean, it's a new area for sure, but it's not any different problem than we've had in the past. Yes, information spreads quickly. There's real potential for abuse, and we can retain flexibility to really go after bad actors. We have to have a more nuanced approach to it. So with that, I've talked for, and I mentioned get to the root problem, which I just mentioned. I've talked for about 75 minutes. That's all I have. You guys have been a great audience, but I'm happy to answer questions as long as you'll want to ask, and any questions you have. So yes.
Well, there's a lot of things you raised, and I agree with many of your points, and certainly, I'm sympathetic to the general agenda of the EFF. I'm in favor of maximum personal freedom as much as possible, but I also would like to make a philosophical counter-argument here. I think if you really want to have a society where you have maximum personal freedom, you also have to have maximum personal accountability. You cannot have a situation where people, for whatever motivation they might have, whether you agree with the motivation or not agree with the motivation, are allowed to engage in various activities which are actually have tangible harm or tangibly harm other people. And that can be in these national security cases, and it can also be even in cases where people are motivated by greed or something like that. You're talking about credit card theft. The one guy who broke into Stratfor had stolen people's credit card information and put it online. So, how is that going to benefit anybody? I don't understand how, even if you're politically motivated and you want to expose some kind of shenanigans about Stratfor, why is putting people's personal credit card information online? Why should that be? How can you possibly justify that? And I just to give you an example, I myself have been a victim of credit card theft. I mean, I got a mortgage some years ago, and some jackasses penetrated that thing along with thousands of other people. And for the last several years, I've had to put up with idiots every several months. Somebody's trying to take out a credit card in my name, and I have to go through this rigmarole talking to people for hours to try to straighten it out. I mean, it's like somebody broke into my house and thousands of other people's house, stole personal information, and are now trying to profit off that information to my economic detriment. I mean, frankly, I think these people should be shot in the head. That's my view about these people. So I agree with you that certainly that in many cases, you can always find examples of abuses in terms of sentences being too high. I mean, you could talk about that in other contexts. For example, the average sentence for murder, at least some years ago, was like 7 or 8 years. And that person get 25-year automatic sentence with a sheet of bladder wrestling. I mean, that's just absurd. I'm in favor of legalization of drugs, legalization of prostitution, and all those things. But I do believe that people who engage in activities which tangibly harm other people should be severely punished for that. And I don't think, defending it on the grounds of transparency necessarily is, you can carry that argument too far.
I think the point about accountability is absolutely right, and I'm certainly not trying to suggest that there's no accountability at all and that people should be free to do whatever they want regardless of the consequences. I think the problem as I see it, is we've taken the concept of accountability a little too far in two ways. The first is the punishment we're trying to impose it's like almost too much, I know you were kind of joking, you're saying, someone should be shot in the head, right? And I imagine that was...
I wasn't entirely joking.
Well, the issue is, there's no question that it's a crime to put someone's credit card information online. I don't have a problem with that. I think it should be a crime. But the question is, does that person, how do we treat that action by that specific actor? Forget the other people who are then using that information, because they can absolutely go get punished. And there's no political motivation behind that. They're just trying to steal money. They're going to get punished, no problem. The question is, how do we treat I say politically motivated, but I think that's kind of a loose term, but how do we kind of create a more holistic, nuanced, balanced approach to it? Now, maybe that's, instead of 10 years in prison, it should be 5 years in prison, or 4 years, or 6 years. I don't know the exact numbers, but the question is, accountability can go too far to the specific actor. And I think that there's a way to recalibrate and rebalance and say, you're going to get punished, you're going to lose your freedom, you're going to be stuck in a 10 by 10 cell for the next 5 years. But there's in my mind, and having been a public defender and representing people who did all sorts of stupid stuff, there's a point where it's once you cross that point, maybe it's 2 years into your 20-year sentence, you're like, I'm never doing this again. This sucks. I don't want to be here. And so I think that's missing. The second thing is that, and this kind of maybe bleeds more into the first point, is we are missing in this whole concept an accountability of government. And that is what's causing a lot of people to act out in this way. I think all of these, let me go back here for a second. All of these people, they want government accountability, okay? The problem is, we live in a time, I think, where the traditional channels by which people can express their dissent is, officially express their dissent are decreasing, okay? We have, we see what? We have elections, millions of dollars spent on elections are coming from big corporations, there are a limited number of people, and the internet has emerged as a way for people on the street without the resources and the means to fund a candidate, for example, or to fund a petition, to really get out and say, hey, you know what? I believe strongly about something. I want the people to know this. I think we're at a time where it's crude, okay? That many of these methods are crude, and they have, like I said, they have tangible consequences that affect regular people. And I think there's still work to be done both at the activist stage in terms of helping people come up with ways to use the internet as a way to prove a point, to make, let your voice be heard, but in a less harmful way than this, okay? And at the same time of having the law keep up with the fact that people are turning to the internet as a medium to express dissent without necessarily throwing the book at them. And we're not at an equilibrium yet on that, and I think we're still going to have some conflict on that. And I think that's, just having the conversation and recognizing that, look, these types of people are going to keep doing what they're doing. They're not afraid of the government. They feel the government is morally, hypocritical. And again, I'm not saying that's a valid concern to have, but that is the way they are approaching it. That rather than just saying, well, we're going to throw the book at them and you have to be accountable and it's punishment, 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 just start thinking, well, maybe there are more nuanced ways. That maybe if the government had been more forthright about its, bulk collection of phone metadata programs and didn't have a secret court that was interpreting the law in secret in terms of the Foreign Intelligence Surveillance Court, then you wouldn't need a person like Edward Snowden to come and leak documents. I know that's a whole separate debate in and of itself, which I don't want to necessarily have, but that's I think what's the underlying tension is. And again, I think it's up to lawmakers, activists, policy people, academics to think about how can we create a more nuanced, balanced approach at looking at these problems and dealing with, creating a law that truly goes after bad actors and punishes them and makes clear that, you cannot, hack into a computer system and steal credit card numbers, but still retain some flexibility to deal with people who are, more like, Aaron, or to treat, the vandalism of the LA Times website article as physical graffiti on an overpass instead of a real serious hacking. So, yes, you back. With a pink,
Thank you.
yeah.
So one of your points for solution was bring the Fourth Amendment into the 21st century. I just wanted to kind of ask you, because historically the Bill of Rights didn't always apply to state governments, it was thought to just apply on the federal level. And so given the fact that there's going to be a constitutional debate about the Fourth Amendment, even though it does now apply in most capacities to the states, do you believe that with the updated mentality, I guess, surrounding the Fourth Amendment and how it applies to the cyber world, if we'll see, if it gets resolved on the federal level, do you see any state governments in the future potentially having debates about this issue? Yeah.
So states are having debates on this issue right now. And I think that the law has to be updated at both levels. It has to be updated at the federal level, it has to be updated at the state level. Now, federal is ideal because it will apply everywhere. The reality is we have a dysfunctional DC and nothing is going to get done at the federal level. And I could tell you, we could sit here all day, and I could tell you about pieces of legislation that would presumably do exactly this. Require a search warrant for location information, require a search warrant for the contents of emails. They've gone nowhere in DC. But what you're seeing now is you're seeing individual states start to enact these types of laws under their state laws. And you're also seeing state courts interpreting their state constitutions to impose more stringent requirements and taking the technology into account. So for example, I mentioned the historic cell site data that can reveal your location. The federal courts have generally said you don't have an expectation of privacy in that information. State courts, who are free to interpret their state constitution and provide stronger protection than the Fourth Amendment, have gone the other way. So for example, in January or February, the Massachusetts Supreme Court said under our state constitution, we say you do have an expectation of privacy in that information, you have to get a search warrant. The New Jersey Supreme Court last year did the same thing. There are other cases in the state courts where the issue is pending where, maybe we'll win, maybe we'll lose, we're not sure. And then in terms of specific legislation, Maine passed a bill that required a search warrant to get location information, including from the cell phone provider. Montana passed legislation. California had legislation pending in 2012 that EFF sponsored with the ACLU of Northern California that it passed through the legislature, but it was vetoed by Governor Brown. Now this year I've heard from legislators in Wisconsin, Maryland, who have similar types of legislation that involve location privacy. So we are seeing the states stepping up where the federal courts and the federal legislature or Congress has kind of lagged behind. And the idea is, if you think back to the Fourth Amendment for a second, the Fourth Amendment is all about reasonable expectations of privacy and what society would treat as reasonable. If more state courts and more state legislatures start imposing more stringent requirements and start to say you have an expectation of privacy in that information, then necessarily, if you follow, if you take the Fourth Amendment at what it says, or what the courts have said, which is it's about what society treats as reasonable, then at some point, when you get a kind of like a balance, 25 or the 26th state that does it, you would start to, you can make the argument that, look, it is no longer reasonable to say the opposite because the majority of people in this country live in a state where under their state laws, they are entitled to have a reasonable expectation of privacy than under their state laws. But it's still very much in its early stages, but there is momentum moving in that direction. Yeah, in the back.
Sure. So I kind of have a harebrained idea regarding Bill of Rights. I'd like to hear your thoughts.
I love
So-
brain ideas for sure. Yeah.
We've talked about the First and Fourth Amendments a bit, and they certainly really apply in communications realm. But what about the Third Amendment as far as the installation of malware, be it rootkits, Trojans, remote access tools, whatever they're using? So the FBI comes in, they install this agent of theirs on your system. It's using your electricity and it's on your computer in your house. Aren't you quartering troops in your house at that point? It's an agent of the government that's living in your house, using your electricity.
So actually, that's not that harebrained. That's actually not a harebrained idea because there's actually a couple law review articles and a case on this. Now, I'll tell you now, I love the idea. We have one obstacle. The Third Amendment applies to militias. It doesn't apply to the government. So the issue becomes, well, what's a militia? And surprisingly, or unsurprisingly, there's not much case law on what a militia is because the Third Amendment doesn't come up in litigation very much. There's a case where a person tried to argue that this police department was a militia because it basically had all this like heavy military equipment, and the court said, no, it's not a militia. So I think that's your problem. Now, if it was the Army that did this, and they have a cyber division, so I don't know, maybe, but I've seen that argument before. I would love to raise it, but I think the problem is the militia angle. I mean, the FBI is not going to be a militia, and so they're the ones who are using the malware. So, yeah.
Yeah, I was curious about your comment about the particularity application and how the request for warrants for all emails, like to the Freedom Hosting site, was overly broad and overly inclusive. And I was wondering, how would you get to be more particular, and who would decide?
So that's actually a topic of very hot debate in the geek law world. And there are a couple court opinions that have basically said the judge, the magistrate judge, the judge who is going to issue the search warrant has the authority on their own, if they want to basically what we call, come up with a search protocol. And to basically tell the government, okay, you can search this email, but you have to follow these procedures to minimize the amount of information you're getting and to make it particularized. So, for example, one of the ways this is done is there's, I don't want to get too into the weeds in this, but basically, you could have, some courts have said, okay, the police department that wants the records, you can get the records, but you can't review the records first. You have to hire an independent person to do an initial screening of the records, filter out the relevant material and give you the relevant material, and then they are to discard the rest of the material, and they're not allowed to tell you what else they saw. So that's one approach. More like simpler approaches that I've seen courts where they basically said, okay, I'm going to give you the search warrant, but you have to narrow your time frame. You want 2 years worth of emails, I'm not going to give you 2 years. You can get 6 months, you tell me which 6 months you want. Or you can get emails that involve communications between certain people, but not, everybody. And, the government oftentimes complains, well, how can we know? The email header may say it's from John Doe, but it's really Jane Doe, and they're disguising their identity. We have to be able to sift through everything. And so there's debate on that, because some scholars have said, actually, the judges don't have the authority to impose restrictions. Other courts have said, other scholars said, yes, they do. And it's actually up for debate. But that's how I would think it could be done, is you have to have the court having more of a supervisory role over how these things are being executed. Yeah?
What about the tech companies and their role in this whole debate? Can they make any steps to increase the level of privacy and security online so that government, like Lavapit guy did, sort of, but he eventually had to shut the whole thing down. What if the initial setup will be built in a way that doesn't give this backdoor to anybody, or, so it's not there. Do you see any movement in the tech industry? Maybe, do you see any role that tech companies can play?
So I think there's a huge role for the tech companies to play, but that the role they can play in the movement are not in sync with each other. So, Logabit is a small email provider, and there are other companies that are purporting to try and do what Logabit did, create really secure forms of communication. There's an iPhone app, and it's on Android. It's called like Silent Text or Silent Phone, which is basically like encrypted text messages and encrypted phones. And I think they are now trying to come up with some new form of encrypted email. And that's a great step in the right direction. We need more companies who are willing to do that. But the problem is, everybody uses Gmail, and everybody uses Hotmail. Maybe not at Hotmail, but everybody uses Gmail, right? And everybody has a Twitter account. So you really got to get those companies to be the ones to impose, to really take an approach. And I will say they're getting much better, and they're now, from like a technical standpoint, Gmail is encrypting messages as they transit and as they're sitting, in their server. They've done a good job of kind of imposing encryption on its services. Not all companies do that. Like Yahoo hasn't been as good. But the real issue is going to be their ability to resist the government is kind of limited, because they're big companies and they have a lot of big business interests, they have big money, and they may want to pick a fight on the government in some areas, but they're going to need the government in some other areas to get a favorable release, or to, if you're Google and you want Google Fiber running through cities across the country, you're going to have to keep a good relationship. So it creates some tension there, where small private actors are making a change, but we really need the big companies to make the change, and their ability to do so is kind of compromised. Now, that being said, I still think they have to, there is work they can do. They can be proactive in protecting their users' privacy rights. They can resist unlawful requests.
They can also educate their users.
Absolutely, they can educate their users. They can, impose stringent requirements for law enforcement access. One of the things that Google reports in its transparency reports is the percentage of requests by which information is turned over, and actually in the last year, those requests have actually gone down, which is a kind of a back way of saying maybe they're resisting more or demanding requests be narrowed. And I don't know for sure, but I mean, if that's the case, then that's a good thing. But yeah, absolutely, the tech companies have a very big role to play, and they have to do. They've talked a lot about wanting to be proactive and protect privacy, but they have to kind of back it up with their actions. And some are better than others.
So along with that question, I'm curious to hear about what EFF is doing against the encryption key development organizations. We were talking about RSA before. So these companies that are selling or offering encryptions that obviously are reported to have backdoors, and they make these agreements that seems inherently illegal. So I mean, how do you pursue those guys? I mean, they can do whatever they want, but then to give the image that they're totally secure, they've used, they put in due diligence to ensure that the security is so high as it can be.
Well, right. So I mean, like you said, we kind of have they can do whatever they want. We have a limited ability to, dissuade them, and we try to dissuade companies that we have relationships with. We don't sponsor products, so we don't recommend. We don't have a specific email provider we recommend you use. We treat them all the same. You do something stupid, we're going to call you out on it. And we've had to do a lot of that really in terms of the tech companies and in terms of the encryption thing, for example. So when the report came out that RSA had kind of like deliberately watered down its encryption at the request of the NSA for a sum of like $10 million, which is kind of nothing. We called them out and we said, if this is true, this is really dangerous, this is really bad, and we don't like it, and instead you should be working to encrypt, and we've encouraged companies to encrypt. Every year we put out a thing called Who Has Your Back, which is kind of like our guide to the ISPs and telcos. We give them like a little star in terms of how they've done in certain categories, and every year we put out that report. It's usually in April, so it should be coming out soon. And that's a way where we can educate the public and hopefully put pressure on the companies to change their practices. Because ultimately, that's really all we can do. We can't necessarily, we're not gonna sue the companies, you know, we can't force them to change anything. But if we can educate the public, and the public votes with their feet, and they vote with their business, and they, you know, have an understanding of what's going on and are making more thoughtful decisions, then the end result is we're gonna have a stronger protection in that way. So that's how we've been handling it.
All right. We're gonna need to call the questions because we have to vacate the room.
Oh, okay.
But
Well,
we can move
outside
some
the
discussion
hall.
outside the hall.